So guys, welcome to another episode of my lecture. In this particular episode, we'll be talking about material or vital evidence versus credible witness. Do you understand? We need to look at the both of them. So now this is the time where we go to my notes, and afterwards we go with the explanation. Let us start with credible witness. Now, this means evidence that is worthy of belief. And for evidence to be worthy of belief and credit, it must not only proceed from a credible source, it must also be credible in the entire circumstance, as stated in the case of AGBI versus OGBEH. Do you understand? Now, the phrase credible evidence also means evidence which is natural, reasonable, and probable in view of the entire circumstances of the case. That's the case of A.M.C. Limited versus VOLKSWAGEN Limited. It is now settled law that the party must prove his case by adducing credible evidence before the burden placed on him by the law can shift to his opponent, as stated in the case of A.M.C. versus ONUOHA. Now, when we are talking about credible evidence, we've not gotten to material evidence yet. When we are talking about credible evidence, it means basically the evidence that we can trust. Because you see, one thing about lawyers is that we are very smart individuals. So we can just be cunning and try to bring evidence to prove a fact. You know, when you're coming to court, you know, the most important thing, or one of the first rules you need to know as a lawyer, is that the court does not care about the truth. The court only cares about the facts, and fact is anything that you can prove. Do you understand? However, when we are talking about you proving, then we also have to look at what is it that you are proving. You have to prove from a source that is credible. That's what A.M.C. versus ONUOHA has said. That whatever you are bringing to the court has to be credible, has to be trustworthy, has to be reasonable in the circumstances of the case. Because it is only when you have done that that we can say that you have properly discharged your burden of proof on your case. If you did not bring credible witness, you brought, for example, you know, when you're talking about credible evidence, it speaks to, you know, whether the document you are bringing or the witness that you are bringing before the court. So permit me, as I use it interchangeably, both evidence and witness. I'm sorry. So yes, it is not just about bringing evidence to courts. Now, this rule has told us that that's the rule established in A.M.C. versus ONUOHA, A.M.C. Limited versus VOLKSWAGEN, and AGBI versus OGBEH. Now, this series of cases have taught us that it is not just about proving, it is not just about bringing evidence to court, it is also about bringing evidence that is deemed credible by the court. And A.M.C. versus VOLKSWAGEN tells us that that's your evidence that you're about to bring. He has to be trustworthy, he has to be reasonable when putting the whole circumstances of the case together. So now let us go to material or vital evidence or witness. What is that? Now, material evidence is that evidence which, on account of its logical nexus with the issue, tends to influence decisively the establishment of facts in issue. Thus, if a party fails to tender evidence which is material to his case, such party would be presumed to be withholding such evidence, as stated in the case of NAS Limited versus UBA. And if such failure leads to the collapse of his case, he should blame himself only for that. That's the case of KUTI versus ALASHA. Also, a vital witness is a witness whose evidence may determine a case one way or the other. When you are talking about material evidence is that piece of information that is needed to decide a case in a party's favor. Is that information that if a particular information is material to a case and the party who is supposed to prove that particular information fails to prove it, you see that the court has said that means that, you know, you have himself to be blamed. So let's say, for example, in a murder case, for example, now at the time where that particular murder happened, the person had an alibi. He was somewhere else in another woman's house. Do you understand? Because he's a married man. He was in another woman's house throughout the night. However, something happened in his office and he was being charged for the murder in his office. Do you understand? But he cannot raise that alibi because it would then jeopardize his family. His wife would know that it means that you were not in your office when you should have been. You were in another woman. So you can see that that information is very vital. Now, it now depends on him. Do you want to bring the information to court? Because it's very material information. Very, very material. If you don't bring it to court, you and only you will be blamed. So do you see how material information works? So when we are talking about vital witness, now to continue with the notes, in other words, he is a person that knows something significant about the case. Now, when you're talking about material evidence is the information. We are talking about vital witness. Vital witness is the person that knows. So most times, the material information is usually held by a vital person. Do you understand? Now, we now talk about credible evidence. It means that, you see that material information, that vital witness, they have to be credible, which means that they have to be trustworthy. Do you understand? So for example, the vital witness in your case might have lost his credibility. Why? Let us say in a murder case, another murder case, the vital witness that you are supposed to bring to come and prove something, let's say to come and prove that he wasn't there because the DNA of the husband was not on the gun. Do you understand? That was used. The murder weapon was brought to court. The DNA of the husband was not there. Now, the doctor that you are bringing to come and prove that the DNA of the husband was not there, because the defense did not want to bring to court that it was in another woman's house. So they wanted to win the case in another way. So he said, okay, since you are not there, it means that there is nothing that they can use to pin you to the place. That means your DNA will likely not be on the gun. Oh yeah, let us bring a medical expert that can prove to us that your DNA is not on the gun. Abi, now this DNA expert that they are bringing, the medical practitioner, he has been caught severally lying on the stand. So when they brought him to court during cross-examination, they brought about 10 different cases when this guy lied on the stand. Then they cross-examined him on it, and then he said yes, that he lied on the stand. You see, that witness is a vital witness, but that witness is no longer a credible witness. Do you understand? So we know what a material evidence is. Material evidence, the information is key. Now, this particular witness has brought a material information, the fact that there is no DNA of the man on the gun. This particular witness is also a vital witness because he's the expert that can speak as to the DNA. But this particular witness has lost his credibility because he has lied severally in different occasions on this particular subject matter. Therefore, the court would attach little or no weight to that particular witness. Do you understand how the three of them go hand in hand in hand? And then the last type of evidence that we're supposed to talk about is the real evidence. Now, real evidence is not too difficult. Real evidence confirms the tendering of material objects like goods, often stolen, weapons of offense, items carrying blood stains or fingerprints, and a great item of forensic value. That's, see, when you're talking about real evidence, oh, he stole my phone. Where is the phone? Let's tender the phone before the court. The item that was stolen, that's real evidence. Oh, he killed her with a knife. Where is the knife? The item as the murder weapon. Let's tender it. So anything that is, tangible, that you can see, that you are tendering before the court, is most times known as real evidence. Do you understand? So this is very easy. So that's the end of the definition and classification of terms under the introductory part of the law of evidence, the course that you are currently enrolled in. Now, in my next section, we'll be talking about relevancy and admissibility of facts and facts in issue. So I will see you in my next lecture.